ability to this national identification card. The clauses make emphasizing that once the person has a national ID card, that the individual will not be required to produce another piece of identity card, because the truth of it, Senator Bunting, is that you do have a number of persons now who may have, say, an electoral ID card. The banks and institutions don't accept it, and that is why they oftentimes get a second one. But the point is that with this national identification card, because the view and the legislation and the authority is basically ensuring that it is supported by other identification cards, such as the passport, driver's license, whatever, that this must be the authentic ID card that institutions should accept.
So I'm just trying to be helpful here, Mr. Chairman. I'm not being adversarial.
Yes.
But I'm just saying, if you say to a bank that you must accept this as the only form of identification, the government through the law says to a bank or any financial institution, you must accept this as the sole, you cannot ask for any additional verification of identity. Then if it turns out that there is a fraud, will the government indemnify that private institution?
Well, it seems to me that is could be a consequence of making it the law.
Yeah, I just want us to go into it, with eyes wide open, so we don't overlook maybe what is an unintended consequence.
Absolutely, because that is why you see, any fraud is detected at all, then it is the duty of the NERA, supported by the government, to ensure that there's absolutely no fraud. Senator Johnson, you wanted to intervene?
Yes, thanks, Mr. Chairman. Just noting that the change in the amendment rather is not intended to mandate institutions to only accept one piece of identification. What it is requiring is that if you accept the national identification that a person from someone, then that must suffice. The point being that it would almost start to make no sense along the lines of simplification. We're supposed to be trying to simplify processes to make it easier for people to open bank accounts, make it easier for them to access services which they are now unable to do or find it very difficult to do because of the number of requirements, because there is insufficient faith or trust in any single ID that exists. The whole point of this exercise is to develop an identification, national identification, supported by biometric information to give it that extra security, which allows for persons to navigate systems more easily. It is supposed to simplify systems. So if we were to not provide for that and to simply allow duplicate, triplicate, parallel systems and everything that existed before to continue exactly the same, then we would be, I'm not sure what would be the point of our exercise. So it's actually quite important, quite an important change. And it's not one that's eliminating fraud protection or any other KYC requirements that banks may have. And if they want to continue with two systems of ID and people bring in their cable bill and light bill, etc., and working with the same set of banked and never banking more, remaining with financial exclusion as we know it as a society. If we remain with everything, if we don't change anything, that will be what we remain with. So I don't see it as a mandate that sort of changes completely how it is that banks can operate. But it is that if we are moving towards a streamlined system, which so far as I understand they want, then this is a necessary adjustment. And it doesn't eliminate them doing other things.
And before you continue, Senator Bunting, I'm going to ask CPC to just put up that proposed 17.1. And go ahead, CBC. Go ahead, Senator Bunting.
Yeah, and I understand the policy intention, and I have no problem with it. However, my concern is that we avoid overreaching. At the end of the day, each institution's directors are responsible to its shareholders. And
Right.
they are also, the board of that institution is also ultimately responsible for the risk management and approving the risk management policies. Now, if an institution determines that it wants dual methods of verification, for example, I'm not sure it's our, I'm not sure it's a government that should be determining, unless, as I said, the government is going to indemnify the institution against any losses that may arise if there is some fraud related to the card. Then otherwise, I think it's dangerous to mandate to institutions what security provisions they must put in place. And as I said, I'm just trying to be helpful, and maybe it may have been an unforeseen consequence. So I'm just raising it for the committee to consider.
No, very good point, Senator Bunting, but it's a policy position. Warren, Warren, you have your hand up.
Chairman, I'd also like to weigh in after Warren.
Right, afterwards. So Warren, go ahead.
Okay, thank you, Chairman. Just to provide some additional information for the committee, as part of the vetting process, remember also that the presentation I did yesterday, there are a number of other identification cards that would be referenced and will also be stored on the system.
Right.
So what you're really doing for efficiency is to carry out the vetting process once and then prevent all of government and private institutions from doing the same thing over and over. So all of the other IDs that exist, so you would in fact be doing the vetting for all of the existing IDs once. And then the individual or the ID owner will be able to verify multiple times. So I think in terms of risk management, I think the controls would have already been in place to manage that.
Right. So Senator Bunting, all right, go ahead, AG.
Just a reminder that the financial industry is a regulated industry, and there are laws that set the parameters for what institutions are required to do from top down within the AML and other framework, the risk assessment, risk management, so that to the extent that the needs would be would already have gone through a verification process involving other pieces of identification, which an institution would allow, doesn't make it problematic to my mind to say that where the institution requires identity to be established, someone presenting the national identification card, that card is to be accepted. I see it a little differently from what is raised by Senator Member Bunting, though
Right.
I understand and appreciate the point he's making. But
Right.
once it is recognized that the regulatory framework exists as a matter of law and what the needs comprises, then it should answer that issue, that question.
Okay.
Yeah.
Thanks, AG.
I understand what you're saying, AG. But just if you just give me one more chance to explain my concern.
No.
And I'm just giving you the benefit of a
Senator Bunting,
practitioner.
just let me make a note, and then you'll come in. Bear in mind, that when the banks would be calling the NERA for verification, you get me? So they would have already started a process. So when they call the NERA, they're really verifying that this is the ID of the person. You see the point? Anyway, continue.
Well, I assume it would not be a call in the sense of somebody picking up a phone and calling, but there's some electronic
Possibly.
means of verifying.
Right.
But I hear what AG is saying, but Again, I'm just trying to give the committee the benefit of a practitioner or a former practitioner in the financial sector. What the regulation sets, you know, the AML, etc., what the regulation sets are a minimum. Every player must meet that standard in order to be licensed to operate. But having established that minimum, many institutions go way beyond or way above the minimum in terms of their fraud prevention measures. So the analogy would be, just because you live in the Constant Spring police station area, the government would not prohibit an individual from having a security guard at his location. This is in addition to the protection provided by the JCF. So all I'm saying is that I would caution not to prevent institutions from adding additional layers of security. Cyber fraud, etc., is a growing problem. It's a headache. It's what keeps directors of these institutions, well, of all companies really, up at night. So all I'm saying is be careful how we restrict boards and companies from putting in additional measures to protect their balance sheet, and ultimately for financial institutions to protect depositors and pensioners.
Chairman, if I may weigh in, fully understand and appreciate that perspective, fully appreciate, and I think it is one to be considered. But as Senator Minister Johnson Smith said, perhaps what will be required is a resolution of the wrestling that is taking place with what a national identification system backed by biometrics should mean in this era where identity is required to be established, and bearing in mind all of the real issues and the practitioners' insight that you have brought to the table. But I can only reiterate the point Senator Johnson Smith made, that to provide a system of the sort that we are putting in, and for someone to opt in, and then life is not made easier for that person, given all the steps that would be required.
That is the point, AG.
My hand is up. Thank you, Chairman, and I hear the perspective, and I strongly support Minister Johnson Smith's point, because that's what I've been arguing yesterday, the day before. Now, I understand what Member Bunting has said, and I'm sure he appreciates that I have a wide range of that kind of experience in at least 9 different jurisdictions. So I understand what he's saying. However, in Jamaica, where the national ID has gone through so much, including the court system, we've revised it and looked at it. If you are going to say this is the unique national ID, and this is important, we must not drop the term unique from the national ID if we're talking about NIDS, because that's what makes it special. If it's unique, there is no other kind of ID that will be as special. In other words, if the bank asks me for my JPS bill and I give it to them from where I live, I could move the next day. Frankly, there have been issues where people have even been able to falsify or defraud other kinds of IDs. Why we're going through this issue, and why I argued so much yesterday, that whatever is going into making the national ID, the NID, unique ID, must be verified. I don't care what it is, it must be verified, so that when it is issued to an individual, no party in this country must then have the right to say, I want something that is better, because the honest truth is, you can't get better than this particular unique national ID. So we must make it clear that yes, while it's voluntary for me to opt in, when I have volunteered and opt in and made that decision, when I hand it to whichever government body or private sector body, it must grant me the right to be identified uniquely as Auburn Hill. And I believe that must not be watered down in any way at all, including for financial institutions. In fact, my argument, Chairman, is this.
Right.
I
Okay.
believe that when this NIDS is issued, the smart financial institutions will insist that you must give me your NIDS over anything else. But whatever it is, it must not be, they can't have the right, they cannot have the right to not accept it as a unique ID.
Okay, thanks, Senator Hill. And by the way, colleagues, when you're speaking, please, PBCJ is carrying it, so they would like you to turn on your camera. Okay, so CPC, could you just read what will replace the present clause 17.1 with what you have on the screen?
Yes, Chair. So 17.1 would now read, an enrolled individual who is issued a national identification card may use the card as a means of proving that individual's identity, and a person requiring proof of identity from an individual who furnishes to that person the individual's national identification card shall not require that individual to produce any additional proof of identity.
Mr. Chairman, I have a request.
Sure.
Is it possible, and this I will have to lean on the legal luminaries in the meeting. I wonder if it would be in any way difficult to put in the word unique before the first reference to national ID. An enrolled individual who is issued a unique national ID card.
I think
that's what we're promulgating.
I think it's tautologist, if I might say that.
Where does the tautology come in?
Because
Because it doesn't say unique anywhere else.
No, but we're promoting it as the ID of the individual. So to say unique, I'm not too sure it adds much to it. Well, what are the other members' thoughts on it?
But that's what we're making this.
The reason is a little different because the card that is referenced in the act is the card which is unique. So by virtue of that uniqueness, given the system internally in the legislation, you would need to, but the word may be used when you are referring to it externally to the legislation.
All right. Okay, thank you.
No, the only concern I have, instead of may use, can we say, it is still, I don't know. We want to say that the individual use the card as proof.
The proposed draft is fine, Chairman, because it speaks to the requirement for an identification, the presentation of it, and how it is to be treated. Those are the three elements in the proposed draft.
All right, and I leave it to the.
I would like to make one thing. It says, and the person requiring proof of identity. I'd like to say a person or entity. That's the point that was being made yesterday.
I think person refers to both the natural and the legal person, but the CPC can guide.
CPC, what do you think? You think you need?
Yes, AG is correct. There's a
you guys are talking to all lawyers.
Interpretation act to include non-corporal entities.
Normal people have to read the law as well. They don't see that.
But
please, you're all talking to lawyers.
Person interpreted broadly, legally, Senator.
I know what it be. Please, Chairman, I know that. But we're not talking to us. The law is for everybody, not just for lawyers and us. Anyway, I'll go by you, but I don't think that clarification would hurt at all, because you know how people are. But if you're satisfied with it, because you guys will go to court and make more money out of it, but go ahead.
So CPC, what Senator Hill, which we is saying, if you say and a person or entity, would not add or detract?
That's not going to take away from it.
I think it would detract, sir, because there's a definition of person in the Interpretation Act. So once we depart from that by adding something else, it then
you create ambiguity. Yeah. All right,
In
so
other pieces of legislation, did you mean, when you use person, you did not then mean corporation, because the body of is read as a whole. This
okay.
is
Minister, may I ask a quick question, please?
Yes, Senator Sinclair.
The provision as it's written there uses the word that shall not require that individual to produce any additional proof of identity. Suppose that occurs, what are we saying? Because the use of the word shall makes it mandatory. What happens in the event that it is not accepted?
Warren, what would be your response to that? But as you can't stop, for instance, Senator Sinclair, say the embassies, because we have no control over
Right,
the
I
embassies.
appreciate the yes, yes.
But as AG points out, let us say the regulatory bodies like the banks and other financial institutions and other companies operating, generally, then there could be a directive that you're, to make it quite clear to these institutions that you should accept the national identification card.
Chairman, may we just note that point so that we can consider how we treat with a refusal to accept it where it is presented and where proof of identification is required. Let's just note it. Point well raised. Yes.
Okay, fine. Thanks then. So we move on and can return to this just to clarify, hopefully by next week. CPC, could you continue where you left off then with the schedule?
Before you move on,
Sure, Senator.
Chairman, I want to make sure that the requirement that entities, persons that have a right to ask for an ID will not then have any wiggle room out of this to ask for anything other once a national ID is, once the uniqueness is given. I would just want to make sure there's absolutely no wiggle room, because I know what will happen. Some people who don't like it will wriggle.
Senator Hill.
Just a minute. Are we covered in every way so there can be no?
And that is why AG, Senator, that is why AG said if we just delay that a bit and amongst ourselves we can have some further discussion.
All right. Okay. I understand. Thank you.
Chairman, alternatively, to put that the identification shall be sufficient proof of identity. We have stated in the converse in terms of not placing an additional burden, but it could be stated that it is sufficient proof of the identity of the person. CPC could consider.
I just don't want any wriggling out of it at all, because the directions are very clear.
So there are two ways of formulating it. If it is sufficient, then there could be no requirement for another form. But
I see where you're going, AG, and I think that might be, because then that would protect them against
a better formulation, right?
Because that then would protect them once they accept it. Then
so you're suggesting EG that the last phrase, put back up the phrase CPC. So the last phrase could be shall be sufficient proof of the person's identity. How does that square with you, CPC?
Trying to understand the proposal. So instead of saying that the person shall not require the individual to produce additional proof of identity, we would be substituting provision to say that once furnished, the national identification card shall be deemed to be sufficient proof of identity.
Yeah, well, put it another way. If you look at 19.2, 19.2 actually says something to that effect.
Actually, maybe we could incorporate both. because you would want to at the same time send the signal to those who are asking for more to be furnished that you should not be requesting so, because this is sufficient.
And I agree with you, AG.
So we could just
That's
add,
what must be conveyed.
and so what could be added there, CPC, let me just guide us. We could add it, and shall be sufficient proof of identity.
Yes, Minister. As AG has suggested, we can use both.
Right. How would that square CPC if we just add and shall be sufficient proof? I think CPC will leave it to you to put in the phrase. Okay.
Yes, Chair.
All right. So we will, when you do it to the CPC, you can then circulate it again. Okay.
Yes, Chair.
All right. So go back then to the schedule. Thanks, AG and Senator Sinclair and Hill. So you could continue CPC where we left off yesterday in terms of Schedule 1.
All right, so we were going through the membership of the authority, and it was agreed that 7 years experience would be required for the persons referred to in C, D, and E.
Right.
Moving to F, a senior public official in the ministry with responsibility for the authority, and that person will be nominated by the permanent secretary of the ministry. Similarly, nominations from the permanent secretary in the ministry with responsibility for national security, an individual from the private sector organization of Jamaica, selected from a list of at least 2 nominees submitted to the Prime Minister by that organization, and a custos rotulorum. And I would like the committee to just confirm whether that person should be nominated by the custodies themselves.
Chairman, may I ask that the submission from the PSOJ be a minimum of 3? Minimum of 2 doesn't give the PM much choice. A minimum of 3 is better.
Could we say instead of nominated by the custodies rotulorum, nominated by the Governor General? Because as you will appreciate, he's in charge of all the custodians. So he would consult with them. Or should appointed rather than nominated, appointed. But they're all appointed by the Governor General anyway, so appointed by the Governor General. Nominated by the Governor General.
Did you get my point, Chairman, where I'm asking?
No, yes. In other words,
you did get it. All right, thank you.
Nominated instead of 2 in each.
At least 3.
Right, at least 3 nominees.
Okay.
And then instead of the custodian, the GG will consult with them. So let it be nominated by the Governor General. Okay, continue CPC.
Right. Then paragraph 2 sets out the fit and proper criteria, the eligibility criteria for the nomination of the members.
The usual, right.
Right. So paragraph A deals with the period of residency that might be required. And I gather that the intention here is for it to be 6 months.
No, I would just say a resident of Jamaica rather than giving any time. In other words, if they're going to be appointed, they should be resident of Jamaica. A citizen.
All right.
One would hope.
Could be a citizen or resident of Jamaica.
Right. I would hope that in the appointment process that is made clear that if you're, I don't know what other members think. I mean, I would need to think that you're going to appoint someone who is living you know, part-time over in America or the UK. I would want the person to be appointed here who will be in regular touch with how the authority is operating. Is that okay? What do you think, members? We just say citizen and a citizen and is a resident of Jamaica.
I support that proposal,
sounds-
Chair.
Yeah.
Sounds good to me.
All right. A citizen resident of Jamaica without saying that they must be resident here for 6 months or whatever. Must be a
Absolutely.
resident of Jamaica. Okay, CPC.
Should be 18 years of age or older,
Fine.
is not or has not been a member of either House of Parliament, not or has not been a member of the Council of a Municipal Corporation, City Municipality, or Town Municipality.
Can't hear the speaker. Don't know what is being said.
It has not been. Why can't we just say?
Exactly, exactly, Mr. Chairman.
I would say is not, but I would remove the phrase has not been. You may have a person who has served in the legislature, the Senate, and the House of Representatives, is no longer active in politics, and who could be a good person because he's a lawyer of 15 years standing or has some other qualification. So I would not include that phrase CPC, and I'm asking for the members' consideration, and has not been. So I agree, is not. So they should.
I agree.
I agree, Mr.
agree
Chairman.
with you,
I agree with
Chairman.
that.
The intention is not to bar someone who has served. The intention is that you cannot be a sitting member and
And
serve.
then also serving as a, right, so remove that phrase in both.
Thank you very much, AG. That's it. You can't keep barring out people who have served and stop serving. Come on.
Absolutely,
Absolutely, I agree.
Absolutely, totally agree.
I mean, in my old age, I may well want to serve. Okay, sorry. Go ahead, CPC.
The person has not at any time been diagnosed as having a mental disorder as defined in the Mental Health Act, and is fit and proper as described in subparagraph 3, and subparagraph 3 gives the fit and proper criteria, meaning the individual has not been convicted of an offense involving fraud, dishonesty, or moral turpitude, or an offense listed in the second schedule of the Post Crime Act, or an offense in any other jurisdiction that is similar to any such offense. The individual is not.
Chairman, the moral turpitude thing is going to exclude a lot of people anyway.
That's okay.
So you don't have to worry about it.
Oh, that's okay. Yes, continue, CPC.
The individual is not a bankrupt within the meaning of Section 2 of the Insolvency Act. The individual's employment record or any other information does not give rise to reasonable cause for the belief that the individual is engaged in any conduct involving dishonesty or impropriety that would interfere with the individual's ability to fulfill any function as a member of the authority. And in the opinion of the Prime Minister, the individual is of sound probity and able to exercise competence, diligence, and sound judgment in fulfilling the functions of a member of the authority. The individual possesses the knowledge, skills, and experience necessary for the functions required to be carried out by the individual as a member of the authority, and the appointment of the individual will not raise an issue of conflict of interest or undue influence. So paragraph 4 deals with the period of appointment and provides that the first appointment of the members of the authority, as regards the first appointment of members of the authority, they shall be appointed for such period not exceeding 5 years as shall be specified in the instrument of appointment, and shall be eligible for reappointment for one or more subsequent periods in accordance with subparagraph B. And as B provides, as regards any subsequent appointment of members of the authority, whether a reappointment of an incumbent member or an appointment to fill a vacancy in a position of such a member, shall be appointed for a period of 5 years. 5 is a usual provision dealing with appointment in the event of the absence or inability of the member to act. 6 provides for the Governor General, acting on the advice of the Prime Minister, given after consultation with the leader of the opposition, shall appoint a chairperson from among the members of the authority. 7, the Governor General shall cause a notification of the names of the members of the authority and any change in the composition thereof to be published in the Gazette. Paragraph 2 deals with resignation, and that's a usual provision. 3,
Okay.
revocation of appointment. The Governor General may revoke the appointment of a member of the authority if the member A is suffering from a mental disorder as defined in the Mental Health Act, or if the member is by reason of ill health permanently unable to discharge any function as a member. B is or becomes ineligible to be appointed as a member, or C engages in any activity that can reasonably be considered prejudicial to the interests of the authority. So the appointment of a member of the authority may be revoked by a resolution passed by a majority of all the members of the authority. And 3, before taking any action under subparagraph 1 or 2, revoking the appointment of a member, the Governor General or the authority, as the case may be, shall notify the member in writing that the member is entitled to be heard on the matter of the proposed revocation within such time as shall be specified in the notice, and shall give the member the opportunity to be heard accordingly. 4 deals with the filling of vacancies in memberships and is a standard provision. At 5, also meetings.
The usual.
Usual.
And the committees are what we have agreed on?
Right. It sets out a general provision to appoint committees, and then B provides for the appointment of specific committees, including 1, the Human Rights and Law Committee, 2, the Enterprise Risk Management Committee, 3, the Information Systems and Cybersecurity Committee, 4, the Information Communication Technology Committee, 5, the Human Resources Development Committee, 6, the Financial Management and Accounting Committee, and 7, the Audit Committee. And each committee so appointed shall be chaired by a member of the authority, and the membership of the committee, of a committee may consist of members of the authority and such other individuals as the authority considers appropriate, having regard to the knowledge and expertise required in respect of the matter concerned. And in 3 gives the authority the power to determine the number of members, the terms of appointments, quorums, and terms of reference of each committee appointed pursuant to subparagraph 1, but in any case, each at least once in every calendar quarter. And then the provisions as relates to eligibility, revocation of appointment, and secrecy and confidentiality will apply to the members of the committee, similar to what applies to the membership of the authority.
Fine.
5 deals with the creation of subcommittees of each committee. 7 deals with disclosure. A member of the authority who is directly or indirectly interested in a contract made or proposed to be made, or in any other matter being considered by the authority, A, shall as soon as possible after that fact comes to the attention of the member, disclose either in person or by notice in writing at a meeting of the authority the nature of the interest, and B, shall not be present during the deliberations of the authority, nor take part in any voting of the authority concerning any decision in respect of the matter. And 2, the disclosure of interest by a member pursuant to this paragraph shall be recorded in the minutes of the meeting at which the disclosure is made. 8, again, pretty standard protection from liability. A member of the authority shall not be personally liable for any act or default of the authority done or omitted to be done in good faith in the course of the functions of the authority. 2, where a member of the authority is exempt from liability by virtue of subparagraph 1, the authority shall be liable to the extent that the authority would be liable if the member were an employee of the authority. 9 provides for remuneration. There shall be paid to the members of the authority such remuneration, whether by way of salary, honorarium, or fees and allowances, as the minister with responsibility for the public service may determine. Moving now to the appointment and tenure of the executive director. For the purposes of section 6, the authority shall, after consultation with the minister, appoint and employ an individual to be the executive director as subject to subparagraph 8, such remuneration and on such terms and conditions as the authority considers fit. 2, an individual appointed as executive director shall hold office for a period not exceeding 3 years and may be reappointed for a maximum period of 3 years. 3, an individual shall not be appointed executive director unless the individual is eligible as described in subparagraph 4. B, the individual's employment record and any other information does not give rise to reasonable cause for the belief that the individual engaged in any conduct involving dishonesty or impropriety that would interfere with the individual's ability to fulfill the functions of executive director. C, the individual possesses the knowledge, skills, and experience, including academic qualifications, technical, managerial, and leadership competencies necessary for the carrying out of the functions of the executive director. And D, the appointment of the individual will not raise any issue of conflict of interest or undue influence. And again, here, 4 sets out the eligibility criteria, and it's similar to what applies to membership of the authority. Right. And again, should this be that the person is required to be a citizen of or resident in Jamaica with the specification of a period?
Has to be.
Yes. All right. So it's the similar eligibility criteria, including the fit and proper criteria.
Okay. Now, Senator Hill had asked some questions about performance.
Yes.
Where the individual, if you go straight to 6, the rest of 5 is the usual, but go to 6 in terms of the appointment of the executive director. That I hope will satisfy Senator Hill to determine how you deal with the executive director. Go ahead, CDC.
Right, Chair. Just without prejudice to any terms or conditions of service applicable under subparagraph 1, the appointment of the executive director may be terminated by the authority if the authority is satisfied that the executive director, A, is suffering from a mental disorder as defined in the Mental Health Act, or by reason of ill health is permanently unable to perform the functions of executive director. B, becomes ineligible under subparagraph 4. C, is convicted of an offense punishable by imprisonment or death. D, fails to carry out a function of the executive director under this act. E, fails to carry out a reasonable directive of the authority. Do we want to retain the word reasonable there or delete it?
Senator Hill, what's your view, and our other members, what's your view? Fails to carry out reasonable directive of the authority? And go ahead.
Chairman,
yeah.
Chairman, that's for releasing the executive director. I am thinking of a time of continuation where we're not dealing with the issue at all of separation. It is the normal continuation of the executive director's role. There should be an annual review of the executive director's performance by the authority.
But Senator Hill, if there is this constant review, because this provides for basically a constant review, wouldn't that be sufficient? In other words, we don't have to
which clause are you referring
to? No, well, generally it says fails to carry out the directive of the authority, or if fails to fulfill performance targets agreed upon between the authority and the director, and the performance targets to be fulfilled by the executive director.
Chairman, that's interesting view. From a management view,
yeah,
the executive director could consistently fail to perform but because the performance is not evaluated, there are no consequences. I am saying that the executive director must perform. If he or she fails to perform, there's an annual review that is going to quickly identify it and take the necessary steps. The performance is quite different from the evaluation of the performance. And so it is the evaluation, the annual evaluation of the performance that I'm seeking. I have no problem with what is written there.
Right, but so would you like to add in if Senator Hill fails to fulfill performance targets, including annual performance?
No, it's not the same. It must be separate. The authority is required to make an annual assessment, evaluation, if you will, of the executive director's performance. Quite completely different from what is written there.
Chairman, I'd like to support what Senator Hill said, because a lot of times persons are in positions, they're not evaluated on an annual basis. You get to a point where the performance is not what it should be. You cannot terminate that person because you have no proof of having done any annual review of the person whatsoever. And then you have to go set in train a whole process to begin to document this person's performance before you can do anything about it. So I totally support what Senator Hill is saying.
And I'm dealing with that. I am dealing with that right now. But just as a management view, I know that even boards, even private sector boards, sometimes, Chairman, when they've done the evaluation and then you come to a crisis and there's no record and you go to the IDT and the IDT say you're unfair to you did not evaluate, what are you going to move them for? They've been good. So please make sure it is clearly stated in there that there must be an annual evaluation of the executive director by the authority.
All right, so we can add, CPC.
Mr. Chairman, I understand the importance of the annual review, but I really wonder if we need to incorporate the policies in the legislation. Wouldn't this be part of the policy, the operating policy of the organization? I think we're getting too granular in the legislation.
Yes.
And I don't think it's appropriate. Let's leave that to the authority to develop its own personnel management policies.
Senator Bunting, I would tend to agree with you if my experience wasn't otherwise. I've seen too many of these now where this kind of argument was made. Leave it to the board, leave it to the authority, and then it's the government, whether it's from your party or my party, that then has to bear the brunt because we did exactly that. We should learn from that experience. And I'm on this and I'm looking at it, I'm looking at the experience, and Chairman, I've seen too many of it. And we know, Senator Bunting knows the case, and we come and hit us in the face. I'm sorry, I'm recommending that, and I'm recommending it strongly. It doesn't hurt at all. It is from that legislation that the board then must make its other policy, but they must be known to be by legislation. You're required to do it.
All right, Senator Hill and Senator Bunting, I don't think it would hurt if we add a G at 6 CPC.
Chairman, if you could just look at what's on the screen, which is takes us back to clause 5. That's the provision in clause 5. 4. Sorry.
Clause 5.4.
Yes.
Members,
It does provide rather generally for the authority to review, evaluate, approve, and monitor the implementation by the executive director of the authority's corporate policies and so on.
Again, that's quite different. That's the broad policy. It is not the evaluation of the executive director's performance. Why are we trying to avoid it? This is the key person in this organization.
I don't think anyone is trying
the
to.
authority must evaluate him or her. We can't avoid that.
But evaluate him or her doing what? It must be in terms of his implementation of the policies, the operational, strategic, and other plans, the annual budget proposals. That is the core of his responsibilities. But just to point out to the committee, I think we need some consistency, because the technical persons had come earlier, trying to specify in great detail things, for example, qualifications, all that. I know that is for the authority or the board of any organization. In this case, the board is the authority to determine these things. We don't have to spell out the approach to managing the organization's work. And I think, we need to be consistent. I mean, if I was part of the technical team, I would be perplexed as to what the committee really wants, because sometimes we go one way and then, another meeting, we forgot what we had directed the last time and we go in the other direction.
Mr. Chairman, with respect, I am not asking for the authority to look at the qualifications or even the evaluations of anybody below the executive director. That's not the authority's responsibility. That's the executive director's responsibility. However, I wanted to be very clear that the authority has a responsibility that must not be avoided, that they must evaluate annually the performance of the executive director and put it on record, so that if there's any issue, our hands are not tied. I've seen enough of it. I'm dealing with it. And Mr. Chairman, this is very vital. We've seen too many lacunas of that happen. Please put it in.
CPC, I think we can satisfy this easily. If we put in FG, fails to satisfy annual performance assessment.
All right, Chairman.
Mr. Chair, may I ask a question?
Sure.
I notice, does the Public Bodies Management and Accountability Act address this issue? I seem to have a vague recall that it does. And the reason why I'm asking is because the legislation that we are approving have to be in conformity with that act.
But I think the problem, Senator Scott Motley, Senator Hill, I've been raising this for a long time. To ensure that the executive director performs, there must be an annual performance.
And that is why I'm asking the question that I'm asking, Chair, because I think that is part of the structure, the framework which we are establishing by making the act subject to the Public Bodies Management and Accountability Act. I have to agree with Member Bunting that we can't be too granular in the legislation, because it actually detracts, in my view, from the legislation.
Senator Scott Motley, through you, Chairman.
If the view is that it is not already covered by our requirement, then of course I leave it to the rest.
SG is annual performance is covered by in the Public Management and Accountability Act, SG.
I'm not sure, Chairman. I can check, but normally that is left to an administrative matter. So, but I understand the concern. I will look in the PPMA just to see if I see anything. And also, there are times when some of those matters are in regulations. So we can check. I may not be able to answer right now, maybe at the next meeting.
No, but
I appreciate that, but I want to just make the point to Senator Scott.
Let SG finish. Finish SG.
Oh, sorry, I thought you was. Sorry.
You finish SG?
I think I thought I heard AG.
Oh, AG,
yes, I was weighing in. So I would issue a general caution that we do not move from one extreme to the next, as we have done in the past, because of performance failures, because of implementation failures and follow-up. I see that at the level of the Constitution with the Charter of Rights. because we have had so many atrocities, so many omissions, we have, instead of looking on what is required to hold to account, we have moved and tied ourselves from one extreme to the next. And no society can properly operate on polar extreme. As a general rule, minor details are not put in the legislation, and some things are left either for regulations or for administrative application as a general rule. I think the issue that Senator Hill has raised is covered in what is set out, and perhaps with just a little tweak of the language. So the authority and the policies in support thereof, and without prejudice, shall review, evaluate, approve, and monitor the implementation by the executive director. I think what he wants is something to speak to the performance, but I do share the view that when the authority reviews and evaluates and ultimately approve or monitor what is to be implemented by the executive director, in effect, that is bringing the performance of the executive director in the spotlight. So if at the end of the day, you shall have reviewed, but maybe the word performance can be added and a little.
Can we do this compromise, AG? That's what I was going to ask for. Reword it and say, the review, evaluate, approve, drop the word and, keep the comma, and monitor the implementation by and performance of the executive director. And that's fine with me, because then that makes it very clear to the authority. I would be happy with that. I don't have to have a separate
so we monitor the performance and implementation by the executive director. You would be happy with that then?
Maybe monitor the implementation and the performance. Let him implement first and then you check his performance.
Okay, so what you want to put performance after implementation?
Yes. Let him implement and performance. Yes, monitor the implementation and performance of the executive director, and that would satisfy.
So the implementation by and the performance of the executive director.
That perfect, Chairman. That satisfies me.
So the implementation of CPC and performance of, and the performance of. So it should be the implementation by and the performance.
Sorry, Mr. Chairman, this is Marlene Aldred.
Sure.
I'm not sure how that works with some of the items in the bullets below. So how do you monitor implementation of annual budget proposals and submissions? It's not flowing for me. I don't know if anybody else sees that.
I don't see a problem because all those things are to be guided by the executive director.
I understand, Senator.
I was suggesting, sorry, SG.
No, go ahead, CPC.
I was just suggesting that if we had it as review the performance of the executive director, including reviewing, evaluating, approving, and monitoring the executive director's implementation of the authority's corporate policies and so on.
I wouldn't have a problem with that either.
Put it up as you just said, Judith, and let us look at it.
You would delete then the submissions, because I don't know. It's one thing to implement a budget proposal, but I don't know how you implement a submission, because the submission is a document you would prepare to get approval.
I suspect you may have to split it in up. Right. Would that be better, SG? But take out the performance in that second under B, then B would remain as it was before, and then
Absolutely.
right. So B
This
would
rendition
remain as
makes
it
it very good.
was, and then A would be stand on its own.
Sorry, Chair. I don't see why we would have performance in B. You have performance in
No,
A.
that's what I'm saying. Take it out in B.
Oh,
She's taking it out, so because it stands on B would be what it was before. Right. And so A, the performance stands on its own in A. Okay, that is okay now, Senator Hill.
Very good, Chairman. Thank you.
So we just add it on its own.
sorry, Chair. Can I just ask to see the chapeau? Because we're saying that.
Chapeau, I think it should be okay, SG.
Yes, thank you, Chairman.
Thanks, SG. Thanks again, Senator Hill and CPC. So we can move on then. We have to go quick to know. Sorry, because we want to see if we can go ahead. No, continue and just highlight the main issues, please, CPC, so we can sign off.
Right. So there are provisions dealing with delegation. Then paragraph 11 concerns employment of staff. I think that's pretty standard as well.
Right.
Same provision as the residency, and it's the same criteria again.
Mm-hmm.
Finances. This is what was.
That was there.
I think that completes the changes that were made to the first.
No, the second schedule is okay, remains.
Yes, the second schedule
Tribunal.
is,
So
is the same.
And then go to the third schedule. No.
Before that, I think we would need to go back to clause 27, which sets out the provisions for the inspectorate.
That's clause 27. Go ahead and.
So these are the revisions for the inspectorate.
Right.
We're now providing that the inspectorate, just for that there shall be a national identification and registration inspectorate instead of providing for the establishment of a body corporate, because it's now proposed that the inspectorate would be the functions of the inspectorate would be exercised by the Electoral Commission.
Fine, yes. And it's in the draft there, right?
Right, and these are just changes that, because of that change, so we're changing the references from up to the board to references to the authority. And in order to prevent any overlap with the functions of the Information Commissioner, we are restricting the references in terms of what the inspectorate would review to just dealing with matters dealing with things that might be contraventions of the Act, rather than to any other laws.
Good, good. All right, continue.
Provisions have been made giving the inspectorate powers to investigate and issue a complaint regarding the conduct or operations of the authority that come to the attention of the inspectorate. And
right.
Your complaint relates to the protection of personal data as defined in the Data Protection Act. Bring the issue or complaint to the attention of the Information Commissioner and make such recommendations and give such directions and advice to the authority as the inspectorate considers appropriate to resolve the issue or complaint.
Good. All right, so continue CPC.
Right, and the additional provisions here have to do in 5 and 6 have to deal with the procedure for receiving complaints. So the provisions of subsection 6 to 11 shall apply in respect of the submission of complaints to the Inspectorate and the investigation of any issue or complaint by the Inspectorate. And subject to those provisions, the Inspectorate may make regulations with respect to its functions under subsection 2F. 6, on receipt of a complaint or any other form of notification as to any issue described in subsection 2F, the Inspectorate shall A, cause a written record to be made of the complaint or other notification as the case may be, and B, issue a copy thereof to the person who submitted the complaint or other form of notification. 7, if the person who submitted the complaint or other form of notification so requests, the written record made under subsection 6 may be kept in a form that renders the person's identity anonymous, and that person shall, at the time of submitting the complaint or other form of notification, be advised by the Inspectorate of the entitlement to make such a request. 8, a person shall not A, disclose or be obliged to disclose the identity of a person who makes a complaint or submits any other form of notification to the Inspectorate for the purposes of its functions under subparagraph 2F, or take any harmful action against a person who makes a complaint or submits any other form of notification to the Inspectorate for the purposes of its functions under subparagraph 2F. And in this subparagraph, harmful action may include interfering with the lawful employment of the person making the complaint or other form of notification. 9, a person who makes a disclosure or takes any action which contravenes subsection 8 commits an offense and shall be liable on summary conviction, therefore, before a parish court to a fine not exceeding $500,000 or to imprisonment for a term not exceeding 6 months. 10, no action, suit, prosecution, or other proceeding shall be instituted in respect of a complaint or other form of notification made to the Inspectorate in good faith under this Act. 11, until the tabling in either House of Parliament of a report by the Inspectorate under a provision of this Act in respect of any matter investigated by the Inspectorate pursuant to subsection 2F, all persons shall regard as confidential the facts and details of the investigation.
Good. All right, so, and that is now being dealt with in the 3rd schedule.
Right, which would deal, that's the 3rd schedule sets out the
Right.
constitution of the Inspectorate.
You want to go through quickly, highlight
Right.
it?
So paragraph 1 provides that the Electoral Commission of Jamaica, established on the Electoral Commission Interim Act, shall constitute and carry out the functions of the Inspectorate for the purposes of this Act. 2, for the avoidance of doubt, the responsibilities and activities of the Inspectorate carried out by the Electoral Commission of Jamaica pursuant to subparagraph 1 shall be construed as responsibilities and activities of the Commission for the purposes of section 19 of the Electoral Commission Interim Act. And section 19 is the provision of that act which deals with the functions of the Commission. So it's just being enlarged to include the functions of the Inspectorate as one of those functions.
Right.
2, provides for the Inspectorate to enter into any memorandum of understanding that the Inspectorate considers appropriate to enable it to retain such services as it considers necessary to retain for the proper discharge of its functions. The Inspectorate power to make regulations relating to its functions. 4, provides for the seal. 5, provides for the Inspector to be able to establish committees for the purpose of facilitating its functions. 6 is a delegation provision where the Inspectorate may delegate to any of its committees or to the Electoral Commission of Jamaica or any employee of the Electoral Commission of Jamaica any of its functions under this Act other than the power to delegate. And the 2 provides for the delegation to be revocable. 7 is a usual provision enabling the inspectorate to regulate its own proceeding and has provisions dealing with quorum, voting, keeping of minutes.
So that's the 3rd schedule.
Yes, Chair. The rest is pretty standard.
Right, and then the 4th schedule, some consequential changes.
Right. Ms. Wilkins, were you supposed to do that portion of it?
Yes, yes, Ms. Grant.
Go ahead.
Let's see how quickly we can do it. So the consequential amendments to other laws, the principle is that we want to ensure that the other laws that touch on concern this matter provide for or contemplate the needs. So for accessing information, it's been amended to exclude identity information. So nobody can request any information through that route that would require that identity information be disclosed. That is the sum effect of that amendment. We're amending the Aliens Act, and in here the intention is to require that the Chief Immigration Officer gives information to the authority on the immigration status of non-citizens, because this is important to the management of the NIDS database.
Right. Then go to 5. There are no changes to 4, but in 5 you have the Data Protection Act.
In 5?
So Ms. Wilkins, I could just with that.
I don't have that.
Right. This is new. So this was it. The committee was to revisit the point of whether the transitional provision, which would have delayed the operation of the Data Protection Act to the functioning of the NERA, if that should have been applied. So this provision would take NERA out of that the delayed operation.
Right. So just a note in the report, Anila and Nadine and Jamaica, that in the Data Protection Act speaks about a 2-year moratorium, but it will not apply to the NERA. In other words, the Data Protection Act, once it comes into operation and the NERA comes into operation, the Data Protection Act will be in place to oversee the operation of the NERA. Isn't that the understanding, CPC?
Yes, Chair. This would exclude NERA from the transition.
That's right. So that is the reason for 5. So that because the NERA will also be awaiting the implementation of the NERA, sorry, of the Data Protection Act. And 7 also inserts consequential matters in relation to the Electoral Commission, and also the Chief Immigration Officer, the Immigration 8.1. So these are consequential changes to the bill because of what we have done from the various proposals put forward at the Joint Select Committee. We have to close out very shortly, but what I'm going to ask Warren.
Yes,
Warren, when CPC has done her final adjustment to the bill, including the highlighting of the changes, can you pass it by the chairman of the Electoral Commission like today or tomorrow, so we can have this comments, by Monday? Is that okay?
We'll do, Chairman, as soon as we receive it.
Right. The point is that the chairman of the Electoral Commission will then see how the act applies to the Electoral Commission as the inspectorate. And CPC, if you don't mind, I'm going to be asking the NIDS team and also the law reform Nadine to go through this carefully so that any correction that needs to be made, they can point it out to you, CPC, if necessary, if
Certainly, Chairman.
it is found. So that hopefully by about Monday, no, well, what I'm hoping, Anila, if the various changes and the removal of the red inscription in the report can be removed, and therefore we can get now what is proposed to be the final report circulated to the members either later today or tomorrow, so that the members have it on the weekend to examine. And hopefully when we come back next Tuesday, we can go through the actual report itself, and therefore we can hopefully finalize by Tuesday, if necessary, Wednesday, and we sign off on the report. So is that okay, Anila? You, Nadine and Kamika, just make sure that everything is appropriate and proper in the final report, so that we can sign off on it by next Tuesday and Wednesday. So I want to thank members of the committee who are with us.
Before you close, Chairman,
Sure, AG.
I just want to throw it to the CPC in respect of the revision of clause 17. Instead of using the word deem for the sufficiency of the needs, is that it be accepted as sufficient. There's a whole heap of academic discussion about this legal fiction of deeming something to be something.
Okay, I think
Yeah.
Yes,
AG,
SG. Yes, AG.
right. So
Thank you, CPC. Good.
right. So remember, CPC. Once we do that, you finalize that draft. We're gonna ask you to circulate it again so members can have a look at it and sign off. Okay. So I want to thank everyone for the meeting today. A fair amount of discussion took place that has affected, how we improve on the draft and also on the report. And we hope that I will be circulating and urging members to have a look at the final report over the weekend, so we can hopefully sign off early next week. Thanks again, members. Thanks again, NITS team, Law Reform, CPC, SG, and others who have joined us. Can I have a motion for adjournment?
So moved.
Thanks again.
Thanks, Chair.
Thanks. I know we move quickly to another meeting, so that's why I'm rushing. So
Yes,
we move to
we
the
have
next.
another one.
Yes.
We know we have another meeting, right? Thanks, though.